Hello, good afternoon, good morning, wherever you may be. My name is Marcy Koski, and I am the leader of our firm's Consumer Financial Services National Practice. We are just a quick few things about our team before we launch into explaining what we'll be talking about today and giving you some other housekeeping items. We are a full service consumer financial services team within a full service law firm. We have a strong expertise both in federal and state law, and we apply that expertise to give clients practical compliance advice. We represent them in single plaintiff and class action litigation and defend companies and financial institutions in every stage of an enforcement action. We represent clients in issues that are big and small, whether related to the most complicated of state laws or the most challenging state regulators or state attorneys general, and with the CFPB, whether led by a Democrat or a Republican appointee. Before we begin in full, I would like to cover a couple housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all of your questions as time permits, but if a fuller answer is needed or we run out of time, we will try to be in touch later. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate numbers will be emailed to you tomorrow, along with a recording of the webcast watching and sharing. Toward the end of the program, please be sure to complete our short survey. We will use your feedback to plan future programs that are applicable to your business needs. All right, that's it for the housekeeping items. Let's get started with our program. Joining me today is John Redding. John has been a legend in the consumer finance space for over 35 years. His practice has a significant focus on defending clients during government examinations, investigations, and enforcement actions across multiple industries and subjects, such as vehicle finance, fair lending matters, and potential violations of credit reporting, debt collection, and electronic payment laws. John has routinely dealt with the CFPB, the DOJ, and the FTC, and other state and federal regulatory and enforcement agencies. He has also represented entities in various state attorneys general investigations. Also joining us is Ryan DiClemente, who has worked with John on a number of state and federal enforcement matters over the years, is also a recognized litigator entrusted with the management of regional and national portfolios. Ryan counsels and defends finance companies and financial institutions against complex claims by consumers and enforcement agencies that arise from federal and state consumer protection laws. And last but not least, we have our partner, Matthew Deere, who is the co-founder and leader of the firm's State Attorneys General Group. Matt, who has built relationships with the front office of state AGs across the country, has built a national practice defending clients across industries from claims made by state attorneys general. All right, let's dive in. Before we kick things off substantively, I want to set the stage here. So first, as a big NFL fan, specifically a Green Bay Packers fan, I'm third generation, I fully expected this weekend to be on the edge of my seat. Were the Chiefs going to three-peat? They didn't, which, by the way, makes the Pack the only team to have a three-peat. All right, back to consumer finance. Turns out it wasn't the game that kept me on edge this weekend. It was all the things that went on with the CFPB. Let's do a quick rundown. So first, January 31st, Chopra finally resigned. He is then replaced by Treasury Secretary Scott Bessent, who is designated as the Bureau's acting director. Bessent is a former hedge fund manager whose political involvement to date really had been limited to fundraising. All right, he's there for a quick minute. We then hear rumors while he's acting director that Doge and Elon Musk come on site to the CFPB. Friday evening, Russell Vogt, who is appointed as the OMB director, is then appointed as the Bureau's acting director. Who is Russell Vogt? Well, his official bio provides that he has spent over 20 years working in DC with grassroots and public policy organizations. He worked for 7 years as the vice president of Heritage Action for America, which characterizes itself as a conservative grassroots organization. Prior to this, he worked on Capitol Hill in a variety of positions. One important item to note is that Vogt wrote a chapter in Project 2025, specifically the chapter on executive office of the president. Looking at this to try to understand more of Vogt's positions and where he comes from, relevant points in that writing say two things that struck me. One, with respect to presidential authority. So Vogt wrote in this chapter that the U.S. Constitution vests executive power in the president, but modern bureaucracy often undermines this authority. A conservative president must reclaim control, limit bureaucratic overreach, and return power to the American people. The chapter also, in summary, states that factors like Congress delegating lawmaking power to agencies, the concept of expert independence, lack of accountability for career civil servants, and weaponized agencies have created a sprawling, expensive, and constitutionally troubling bureaucracy. So those are important things to keep in mind as we set the stage for our discussion today. All right, well, that wasn't the end of what happened this weekend. Two lawsuits were filed yesterday by the National Treasury Employees Union. The first against Vogt as the acting director seeking declaratory and injunctive relief, claiming that the CFPB unlawfully disclosed its employees' personal information to members of DOJ without proper legal authorization in violation of the Privacy Act and other federal laws. The second, also filed by the Employees Union against Vogt, alleges that Vogt's actions to halt the CFPB operations violate constitutional separation of powers principles, specifically that his directives unlawfully interfere with Congress's authority to create and fund federal agencies. So, look, this is a new CFPB, but the CFPB is not going away. For example, rules that have been promulgated under the APA cannot go away without the strike of a pen. There's a process to follow. But more to the point, looking at certainly going to be a bevy of activity, but again, the CFPB is not going to go away. We will see changes such as reshuffling of the organization and replacement of senior officials. And we do know, as we saw when acting director Mulvaney was appointed, that the director has the ability to impact funding and priorities. Okay, so what has happened? What has been the impact of the acting directors? So first, when Bessent was the acting director last week, he had sent an email directive to staff instructing CFPB to halt the majority of its operations, including refraining from issuing or endorsing proposed rules or final regulations, postponing implementation, dates of established but not yet effective final rules, avoiding initiation or resolution of enforcement actions, and ceasing publication of any form of communication, including research reports. Over the weekend, Vogt issued a similar directive, teasing some of those points out further, including that the Bureau is not to approve or make appearances in litigation unless issuing any sort of public guidance documents, and ceasing all stakeholder engagement. Vogt also indicated that he would not seek funds at the next scheduled draw, as we will talk about later in the webinar. This was the same act that Mulvaney took, who requested $0 from the Fed for the first new quarter of his tenure in January 2018. Vogt also ordered all employees to work remotely. Now, 2025 said about the CFPB. So in summary, the CFPB chapter of 2025 argued that the CFPB operates as an unaccountable agency with no congressional oversight and accuses it of funneling funds from civil penalties to politically aligned left-leaning nonprofit. It also has several calls to action to Congress, asking Congress for the next conservative president, under the next conservative president, to ensure that CMPs are not used to recompense wronged consumers who go to the Department of Treasury, rather than be retained by the Bureau to be dispensed at the pleasure of the director. It calls for repeal of Section 1071. It calls for a requirement that no CFPB funds be spent on enforcement actions that are not based on a rulemaking that complies with the APA. So the amorphous, ambiguous UDAP authority that the CFPB has been using in its enforcement action. Require that respondents in administrative actions be allowed to elect whether adjudication occurs in an administrative law court or in Article 3 federal court. And finally, to specify the nature of deceptive, unfair, and abusive practices to define the scope of the CFPB mission more precisely. All right, well, there's certainly more flurry of activity to come, including awaiting the nomination of a candidate for a permanent director. But with that, I'd like to hand it over to Ryan.
Thanks, Marcy.
Before you get started, we got a question about whether the acting director has the authority to stop the funding of the Bureau. And, this is an authority that obviously is granted to the director, in that the director gets to make a request to Treasury for funding. As we know, under prior Director Mulvaney, he did something very similar, which I know, Ryan, you're going to touch upon. But the acting director does, in fact, have the authority to decide whether or not to seek funding. So just thought that was an interesting question.
Yeah, and I think it's more about what happens if they don't seek the funding, right? Like, I think that they can stop funding, but I'm not sure that they would be able to stop all supervisory activity, for example, John, right? Or enforcement activity.
A great point. The acting director has the same authority as a director, as a permanently appointed director. In this case, both Secretary Bessent and Director Vogt were appointed under the Vacancies Act, which is, that's how Mulvaney was appointed during the first Trump administration, and that matter was resolved in favor of the ability to make such an appointment. And that also grants the acting director, for instance, the authority to pause enforcement activities. I think, and we'll touch on this a bit later, I think the question of whether they can pause versus terminate supervisory activities, I think, is much more interesting, particularly given the language of Dodd-Frank.
Yeah, and I think with Mulvaney as well, which I'll touch on in a minute, the fact that they didn't seek funding, they were still funding the Bureau through the reserves, right? And so that's also an important distinction, which is it's still being funded. It's just being funded from another source.
It's really just money they have on hand. And, there's been some interesting back and forth, and we'll see how it plays out. Acting Director Vogt stated that they have $711 million on hand. But interestingly, in some reporting today, they're saying that that may be closer to between 100 and 200 million, which, again, the Bureau can request funding to accomplish its mission. And the 711 million, if that were really the number, would seem to be a sufficient amount for what the Bureau has stated it has on its plate and intends to do. Granted, that predates the appointment of Acting Director Vogt, but at 100 to 200 million, they may not. And therefore, then the question becomes, is there enough to do what they've said they're going to do and the priorities that they've stated they have? And I believe that at least one consumer advocacy group, I believe, filed suit today asking that very question and making that very point. So obviously a lot in flux here. It'll be interesting to see.
Yeah, and it looks like they're spending about $200 million a quarter to fund the Bureau currently. But again, that's subject to change. But, you know, as we discussed, today's CLE is going to focus on the future of enforcement. And I think it's really important to analyze the actions and priorities of the Trump administration's first term to understand a little bit about where we could be headed. Of course, we all know there's no guarantee that Trump 2.0 is going to follow the priorities of the first term. But I think the history is really important in beginning to prepare for the next few years. So as we discussed, Mick Mulvaney was appointed as interim director in November of 2017. And after arriving, he instituted a hiring freeze. That hiring freeze lasted for nearly his entire tenure and also resulted in a double-digit reduction in staffing, something else that we may see coming down the road. In addition, we talked already about Director Mulvaney requesting no funding from the Federal Reserve for Q2 in 2018 and funded the Bureau from the reserves they had on hand. However, they received funding from the Federal Reserve for the remainder of 2018. Now, as far as enforcement activity, Director Mulvaney instituted very few enforcement actions during his interim tenure. This wasn't entirely unexpected because there is always a pause and a reassessment of pending actions. During Director Mulvaney's congressional testimony in April of 2018, the director pushed back on the idea that he wasn't pursuing action for what it's worth. But as you'll see from the numbers, Director Mulvaney's actions that he instituted were actually significantly lower than just about anybody else that was in charge of the Bureau so far. He described his enforcement priorities on being focused on the quantifiable and unavoidable harm to the consumer, and indicated that the Bureau wasn't looking for excuses to bring lawsuits, which I think is just kind of an interesting perspective on how he viewed enforcement. During his tenure, he acknowledged he wasn't there to shutter the Bureau and acknowledged that he couldn't, and repeated the mandate to follow the law. And this is a mantra that was also appointed by Director Kraninger, and we're going to talk a little bit about that. Now, certainly I think there are some parallels between what happened under Director Mulvaney and the types of steps we anticipate to see and already are seeing, like a hiring freeze, a request for no funding, and a potential reduction in workforce.
And
So
I'll,
Marcy, yeah.
Ryan, just on the hiring freeze before we talk about or do the survey question, which as many of you here know we have to for CLE purposes. But on the hiring freeze, as many of us know on this call, right, Director Chopra was really pushing to recruit attorneys, particularly in the enforcement division. So to the extent there is a reduction in staff, the agency, nevertheless, it's still a big agency.
Yeah, I think that's absolutely right. And when you look at how the Bureau is made up for its staffing, about 44% are enforcement and supervisory. So one of the largest portions of the Bureau is made up by enforcement and supervisory. Marcy, do you want to read the next?
Yep. And I see people are already submitting. Are there duties that the CFPB is required to undertake per the Dodd-Frank Act? In other words, does the law require them to act, do certain things? Yes or no? Give you a couple seconds. 50-50 shot here, people. All right, well, about a material amount of you have answered. And let's see, does it tell me? I'm not sure if I know the results. Let's see. People are still going. Here we go. So yes, correct. Very smart audience. There are definitely duties that the CFPB must undertake per the Dodd-Frank Act. And right now we are teasing out what exactly is required under the Dodd-Frank Act, looking at what is a shall versus what is may. And we'll talk in further detail, but one is that the CFPB must supervise entities that are under its supervisory jurisdiction. Ryan, back to you.
Okay, so next we're going to talk about Director Kraninger and her period of as the Bureau's director that began in December of 2018. And I think her 2 years of enforcement activity are important to analyze because in describing her role recently as the director, she explained that it was to effectuate the priorities that were set by the Trump administration, which is not surprising, right? And she also explained that the administration was not looking over her shoulder. And I think we can anticipate a similar structure in the second Trump administration. And so by looking at the enforcement activities, I think we can begin to analyze what did the original Trump administration think was important and how did they look at enforcement? So for those of you that are hoping enforcement will cease, I think you're going to be disappointed. Director Kraninger's history supports this. She described the Bureau's enforcement mission as, quote, using all of our tools, right? All of the Bureau's tools to go after actors that break the law while building a culture of compliance by having smart and clear rules of the road as well as a robust supervisory examination process. That's how she described her mission. And as the next slide will show, she was quite active during her tenure in bringing enforcement actions. And depending on who gets appointed to lead the Bureau, we could see a similar level of activity, but with some important distinctions that we're going to talk about in the next few minutes. But this concept of enforcing the law is something that was repeated during her tenure, during Mulvaney's tenure, and seemed to serve as a guiding principle. Now, while follow the law may be a self-evident, obvious concept, and bringing actions for legal violations, it's very different than I think what a lot in the industry believed they were subject to under the last administration, under Chopra's control of the Bureau. Because a lot of clients seem to feel, and I think many did, that they were initiating enforcement actions in an attempt to create or expand the law, which is something that I know that we've seen a lot. So I just want to pause there for a second to see if either John, have any thoughts about that.
Yeah, I mean, I guess what I would say is I don't think there's any question that enforcement was used as a tool to expand legal obligations. We can think about in the auto finance industry, the Bureau's approach to ancillary products and the refunding of unearned amounts. We've seen the Bureau taking other kinds of actions, for example, dealing with insurance proceeds in a lease total loss situation. So there's no question that I think in my mind, and I will be the first to admit I'm a bit biased, but in my mind that they were using enforcement to expand the law beyond what it really said. And it's not a new or novel concept. We saw the same thing in the first administration where Cordray was our director. And I think this is one of the things that we all talk about when it comes to appointment of a director. Unlike the Federal Trade Commission, we don't have a commission. We have a single individual in whom the power is granted, and they're going to act in a manner that is consistent with the administration, but there's nobody there to stop them. And I think that's important. And it's always interesting because the party out of power always wants a commission right until the moment they come into power, and then they forget because, of course, now my person is in. And, it's job of a politician is, of course, to get reelected. And so, if my person's in, they're going to do what my constituencies want, and therefore we'll leave it as is. I think that's one of the interesting things. But I would certainly say, based on what I saw during a Cordray administration from an enforcement perspective versus a Kraninger versus Chopra, it's very clear how the Bureau is used by various administrations based on party and power to either really seek to just enforce the law or seek to expand the law through enforcement.
Yeah, John, and all those points are well taken, particularly the one on whether, if your guy's in power, your person's in power. I just want to make a comment going back to this slide about the Trump administration not looking over Kraninger's shoulder in the operation of the Bureau. What's interesting to me, right, is yes, Cordray at the time, we thought he's really aggressive. And then we had Director Chopra, and he was ultra aggressive. And in my mind, he put a target on the back of the agency, right? People are attentive to what the agency is doing, in my view, because of the actions of Director Chopra. And I think in part what we're seeing now is a reaction to that. So I'll be curious if the Trump administration, whether it is more engaged, if Trump himself in the front office at the White House is more engaged in the operation of the Bureau. Remains to be seen, but I think, again, this could be a difference where Trump 2.0 is different from Trump. Back to you, Ryan.
Yeah, I don't disagree that it may be different, 2.0 versus 1.0. It certainly feels different in some respects. But, I would tell you that having been dealing with supervision and enforcement at the Bureau since it began, Cordray, I would tell you, definitely put a target on the back for Republicans. Mulvaney and Kraninger for Democrats. And so, again, I think this is just one of the things we have to get used to, and it's unfortunate, is that this is just a political animal. And while it is a single director with this level of power, it is really just a political animal, in my view.
Yes, I think those are all really good points. And I mean, what do the numbers say, right? Because I found this chart, which was pulled directly off the CFPB's website, to be interesting. And so what this shows is the enforcement activity by filings, by year. And so when we look at the numbers, what we see, as we discussed originally, is that Director Mulvaney's tenure enforcement activity decreased significantly. It was the second lowest since the Bureau was created. And with only about 10 enforcement actions that were actually filed during his tenure. I think what's surprising to a lot of people is when you look at 2019 and 2020, where Director Kraninger was in charge of the Bureau, and the significant numbers of filings that were happening for enforcement activity during that time period. I think the other thing that's kind of interesting is when we talk about outgoing Director Chopra, what was how many enforcement actions were filed during, that administration? And when you look at these numbers, I actually think the 2024 numbers are bolstered by the flurry of activity that happened at the end of the last term. I think those numbers are actually propped up because I think there was at least a dozen, if not more, actions that were filed at the end of 2024. But it's not just the numbers that tell the story. I think it's more interesting and more informative for clients who are looking to see what's happening is what types of matters were being filed, right? What were the actions and what were some of the themes that we could look at? So in reviewing the actions and consent orders brought by Director Kraninger, I think there's a few common areas and themes that we can see during 2019 and 2020. First, I think we see actions brought under a more classic UDAP theory. And what I mean by that are actions that are arising out of disclosures, advertising, marketing, and fraud. Claims that appear to have an actual connection to consumer harm. I think that those were a lot of the actions that were being filed during this time period. And I think it's actually what distinguishes from the Chopra administration, particularly in the area of actual consumer harm. We can also see some of the administration's priorities through those matters, including the numerous actions that they pursued against companies that were targeting or taking advantage of military or service members or their families. the number of fair lending actions that were filed. During Director Cranninger, they were not shy about asserting claims or bringing matters against large companies or larger participants. They initiated numerous actions based on alleged FCRA violations. I think this is really important to note because I know this is an area of potential risk for clients. And it's not something that I see going away or changing under Trump's second term or with a new director. We also saw actions that targeted what could be described as predatory against vulnerable consumers. Again, more kind of traditional UDAP violations.
Hey, Ryan, just to mention on the fair lending point. So as we'll all remember, the Townstone matter, the Townstone case was filed in the Northern District of Illinois. The CFPB filed a lawsuit against Townstone, a mortgage broker, for statements that it made on a radio show. It hosted a talk show radio that was largely an advertisement, but the host said some pretty atrocious things, and the CFPB alleged that in part those comments violated the Equal Credit Opportunity Act because it discouraged prospective applicants from seeking a mortgage with Townstone. The Northern District of Illinois concluded that applicant under ACOA couldn't be defined under Reg B to include a prospective applicant. But when that went up to the Seventh Circuit said the CFPB was well within its statutory authority to define applicant to mean prospective applicant to ensure that they're under its discouragement provision, it was permitted to, the CFPB was permitted to interpret it that way. And that came from tenure. And so that will have, of course, lasting impacts on the application and the broad application of the Equal Credit Opportunity Act. So just to emphasize the point that you're making here.
Yeah, I think that's great. So the next slide, what I wanted to do is just give a sampling, right? I mean, what are the types of claims and the amounts of redress that were obtained during Director Cranninger? Again, these are not insignificant actions or numbers, and demonstrate again some of the themes that we discussed in the prior slide. So, for example, you had Santander Consumer USA violations as a furnisher, right? And included a $4.7 million CMP. You have a Discover Bank action that involved, among other things, alleged misrepresentations and misstatements of minimum payment amounts, along with claims of improperly withdrawing funds without consent. That was a $10 million redress and $25 million CMP. You had NationStar, right, which was the largest, I think at the time, non-bank mortgage servicer, allegedly causing substantial harm to borrowers that it serviced through its servicing activities, including the offers that it provided to distressed homeowners, $73 million in redress, $1.5 million in CMP. TD Bank, again, we talk about traditional claims arising from marketing and sale of its optional overdraft service, $97 million in redress, $25 million CMP. Equifax, everybody remembers, arose out of a data breach situation. USAA, alleged violations of EFTA for failing to proper honors consumers' stop payment requests on pre-authorized electronic fund transfers and failing to initiate and complete reasonable error resolution investigations, $12 million in redress and $3.5 million in CMP. So again, just a sampling of the types of activity that was going on during that time, and I think highlights some of the themes that we've been talking about. But the great part about having John Redding join our firm is the fact that we have somebody who, frankly, was litigating all of these issues with the Bureau during this time period. So John, under the last administration, Trump 1.0, what were you seeing on for these types of activities, enforcement activities? John, are you on mute?
I was, and I couldn't get off it. So these things happen, technology. a lot of what we were seeing was exactly the kinds of things you'd expect and the types of things that Director Cranninger was talking about, and that is violations of law. And the real differences that we saw were it wasn't an attempt to expand into as much policy-driven issues and create new law. It was fair credit, fair debt, service members, EFTA. We were seeing all of those, but it was straightforward violations of law that you could argue over, as opposed to, I don't like this, which is what the Chopra administration felt like. The other thing that you see is that the demands that we were receiving under the Republican administration, the prior Trump Republican administration, that those demands were first and foremost, initially lower, more reasonable. Second, if consumers were actually harmed, if the Bureau was showing actual harm, yes, we would see redress. But generally speaking, you would see civil money penalty. And you can feel about that how you like, but it was just a more normalized approach, and what you would expect out of a government agency that, if you've been dealing with the Department of Justice, the Federal Trade Commission, for unfortunately decades now, that's how it works. And so I think that was really one of the key differences.
Can DOJ unilaterally shutter the CFPB? Yes or no? Let's give you a few minutes to submit your response.
And Marcy, I also just wanted to note, we have a number of questions too queued up. We can either put those for the end or just try to deal with some of them as we move forward.
I was thinking of maybe running through some of them as we get started talking about the future.
That's
yeah,
great.
That sounds like a good plan. All right, let's see. We have a material amount who have answered. The correct answer is no. CFPB is an act of Congress, so it would require an act of Congress to unilaterally or to shutter the CFPB.
All right, so what's next? Before we get to that, you all can read. Let's talk about some of these questions. So one of the questions is, have there ever been similar signaling as it relates to stopping supervisory activities similar to what we're seeing now, or is the messaging novel? Obviously, we only have a limited sample size, 2. But based on what we saw in the past, I would say that this is different in the nature and the strength of the signaling. The idea that all supervisory activity would cease immediately and that Bureau employees would be told not to do any further work. There were, in prior administration changes, some slowdown in supervisory activity, in the examinations, where there was some reassessment of, are we focusing in the exams on the things that the administration deems important, but not this type of wholesale activity. And so I would say that this is a bit different. It will certainly be interesting to see what comes out of it. I think one of the things that is important to note, and was mentioned, I think, by Marcy previously, is that the Bureau does not have the ability to unilaterally cease the engagement in supervisory activities. The Dodd-Frank Act, specifically for those of us who like to play law nerd, 12 U.S.C. 5514 subpart B, makes quite clear that the Bureau shall engage in these types of supervisory activities. Now, what that might look like, what they're going to focus on, who they may deem to be presenting higher risk to consumers, all of that is subject to question. But the idea that the Bureau can simply stop and decide that it is not going to engage in this activity is going to be problematic. So I think that it is certainly different in terms of strength and scope, but not entirely unheard of in terms of reassessing for priorities. We had another question. Do we think they will highlight the good the agency has done aside from the focus on overreach? You know, it's always interesting. I suspect right now the answer to that is unfortunately no. I think right now we're going to be hearing just a lot of noise. We've been seeing this in other areas of the government. I do think there will come a time where there will be a recognition of some of the positives that have come through the Bureau. We can all argue over whether they really are. Obviously, if you were on the receiving end, you would say it was not. But nonetheless, the protection of consumers, the ensuring compliance with the law, which creates a more level playing field for everyone involved, I think those are the kinds of things that may eventually become a topic of discussion, but for the time being, we certainly aren't seeing much of that. The next one was, is there any remaining desire to restructure the Bureau into a commission, or does everyone now seem content that it is a political animal to be wielded by whoever is in power? And I love this question. It's just one that's near and dear to my heart. You know, I've been working with against the Bureau since it began. And, you know, a commission has a lot of benefits. You get, it doesn't become sort of a star chamber or an echo chamber where they're only listening to themselves. You know, one party has the power. Unfortunately, as I mentioned earlier, you know, it always seems that the party that's out of power wants a commission because, of course, they have no power within the Bureau. And then when they get back in, they, of course, want to leave it as is. If you remember, during the Cordray administration, Republicans were screaming for a commission. They didn't get a commission. And what happened? Trump 1.0, you saw Mulvaney and Krininger, as we've talked about, the Democrats started crying for, you know, out loud for a commission. We didn't get one. They were back in power. All of a sudden that ended. So unfortunately, and maybe it's just the cynic in me, I don't see a commission coming to be, but we will see what happens. Another question is, if the CFPB were to stop all supervisory and enforcement activity, who, if anyone, would have standing to file suit to force them to take action? In other words, is there a remedy? That's interesting. The who would have standing. First of all, the Bureau, if it truly stopped all enforcement activity, it would be interesting to see whether there is a mandate that they have to. But on the supervisory side, I know that there is. I would say that, you know, I don't know who has standing, but I would have to imagine you would see consumer activist groups claiming standing, and potentially others. I could see potentially states trying to do so. Perhaps AGs might have the authority under Dodd-Frank. I don't know about that one. So I'd have to say that's one we should probably figure out and get back to the group on. I think that's a good one.
Yeah, and John, just as a reminder, right, the employees union at least filed a lawsuit that, and it believes it has standing to seek injunctive relief to basically force the CFPB to continue to operate. So.
Yeah. So I know we've got a few minutes, and Matt, I want to leave some time here. You know, enforcement, the reassessment is normal. This is a normal part of the process on the enforcement side. So I don't think that this is particularly unusual. We'll see where it goes next. I anticipate that to the extent there are matters out there that are inconsistent with priorities, those will go away quietly. For some, the scope of them will change, and for others, they will simply proceed. Interestingly now, even during the pause, it's important to note that both when he was acting director Besant and now Vogt, in their direction to stop, they have left open the idea of being able to conduct legally required activities. So court deadlines, et cetera. We'll see more focus, I think, on civil money penalty, less on redress where there is not a specific identified monetary harm to consumers. I think what that means is overall you tend to see some lower total settlement amounts, but it is all civil money penalty frequently. We used to see that in fair credit. That changed during the Chopra administration. The last one I think that's important is for people who are under orders. Have been getting a lot of questions, I know we all have, about, well, I've got a consent order, do I stop? And I would tell you that even courts that have looked at this previously have said a consent order is really a contractual arrangement between you and the agency. And whether it is this administration or the next administration, if you're under a consent order and you're not following your obligations under the consent order, someone at some point is going to come looking. And you want to be very careful. Obviously, Director Chopra started the recidivist group to address people who were not basically complying with consent orders or were a repeat offender. You know, no matter what happens here, no matter, you know, whether the Bureau is gutted completely or whatever may end up happening, don't think that we're not going to have another Democratic administration, another Democratic director, at which point, you know, if we've been playing too fast and loose, you know what to expect. Remember, the Bureau is looking backward. They're not looking at what you're doing tomorrow. They're looking at what you did yesterday. So I think that's very important. There is a question about MRAs, and that's an interesting one, noted about consent orders, but what about MRAs? It's important to remember that even under the Chopra administration, Director Chopra came out and made very clear there is no legal authority to enforce MRAs. None. But I can tell you from experience, if you're not satisfying MRAs, the Bureau will come back in, well, whether you are satisfying them or not, the Bureau will come back in under its supervisory authority, examine again, usually for compliance with the prior supervisory letter that included the MRAs. And if they consider the MRAs not to have been satisfied, they will then initiate an enforcement action. So you go through exam one, you get your MRAs, you take as long as it takes to satisfy the MRAs. You typically will report they're complete. And at some point thereafter, the Bureau will come in and look again. And so you go through another exam and they will test for exactly this. And if those MRAs are not satisfied, they will initiate enforcement actions. And unfortunately, I've been through that a few times. So I do know that is the process, unfortunately. Let's talk for just a moment about supervision, then Matt, I'll hand off to you. First of all, supervision likely to continue. As we've talked about, the Bureau really doesn't have, the director doesn't have the authority to say there will be no examinations. Now, the areas of focus may change, the scope of them may change, who they identify may change. But I don't envision this being a zero activity environment. In terms of impact on risk-based supervision program, that has already been stopped by the acting director, that there will be no designation of parties who are not subject to a larger participant rule as being subject to the 2-year supervision authority when identified as a higher risk participant. It'll be interesting to see what happens with those companies that were previously identified as high risk. Typically, supervision is for a period of 2 years. It is possible that this current administration could walk away from those or elect not to examine those entities. But for now, what this authority, which Director Chopra during his administration identified as their dormant authority, I think that is likely to be on hold. And so it will be interesting to watch that aspect. There is also a question about rules that we got. A few things. First of all, there is a pause on all rulemaking. There is a pause on the effective date of any rules. Now, it would seem that the Bureau has to make some kind of pronouncement that it is extending the effective date to sometime past the currently scheduled effective date, given that they are final rules that had initially had an implementation date. When that will be, whether, for example, the payday rule will ultimately go into effect, we don't know yet. But it will be interesting to see in light of the pause that has been given. Lastly, there was, as he was on his way out after having been informed by the Trump White House that his services were no longer needed, he came out with a message basically pushing the states to take action, outlined state enforcement authority, identified some of the issues that were important to the Bureau, and basically suggested that both state AGs and the the legislature should take certain actions on issues that are important. And by the way, we just got a question that's a favorite. Can I sue the CFPB for the millions of dollars we've spent to comply with the 1071 rule if it's rolled back? I so wish I could answer yes to that one. I truly wish we could. I suspect not, unfortunately. But we shall see where this all goes. And with that, Matt, let me hand off to you to talk about what we should expect from state AGs.
Yeah, thank you very much, John. We heard John talk about the difference between enforcing the law on the one hand and expanding and creating law on the other. Of course, the modern state attorney general plays a greater role in the daily functioning for many companies, including, I'm sure, many of yours, where AGs, whether alone or through coordination, can shape an entire regulatory environment. So I will get through a couple slides, but I also, want to make sure that everyone gets the benefit of John, Ryan, and Marcy's expertise, and I know there are probably a couple more questions. But in addition to the report that John just referenced, former Director Chopra also recently authored an article in the Harvard Law Review that I thought was interesting, entitled State Enforcement as a Federal Legislative Tool. And it included a number of statistics that are here on the page. I'll read some of them off, but the interpretive rule, of course, which was effective May 2022, confirmed that states have the authority to enforce the CFPA. And again, some of the statistics were 50 total actions by states under the CFPA, 2 actions involving all 50 states, 7 additional involving multiple states, and then 23 states involved in at least one other action, whether solo or jointly with the CFPB. And of those, 15 were joined by the CFPB. Also, because we're getting somewhat close to the top of the hour, I also ought to make sure we get this final question done for the benefit of everyone's CLE. Marcy, you can read it, or
Yeah. Will the alphabet soup regulations go away if the CFPB is minimized? And I guess the follow-on question would be, and if they do we get to sue for all the times we tried to comply with that? All right, no, that's exactly correct. Back to you, Matt.
Okay, so we'll skip past that. So just trying to forecast a second Trump administration. While the CFPB's actions may be somewhat up in the air, and I thought Ryan, addressed that expertly, to me, it's a little more settled that I expect to see increased AG engagement, particularly from Democrat state AGs. I think the next 4 years, as the slide states, will likely see increased state enforcement. Going it alone, I can tell you anecdotally that this coming week at the Democrat Attorneys General Association, which our firm attends and represents clients at, one of the panels that they're offering is the role of the AG in regulating new financial technologies to protect consumers. They have to choose very carefully, among topics, and I think it's telling that one of, I think, maybe 3 panels is on a consumer finance subject. So it's a timely topic, and I think an important one. And again, thank you for all joining today. So, I think it's an open question whether we see more or fewer joint enforcements among the CFPB and state AGs. My personal opinion is fewer, kind of for many of the reasons that John and Ryan talked about. I think the slide states, state AGs could take the mantle of paused CFPB actions. I think actually probably much stronger, and I think they already are from some of what I've read and other materials that I've listened to. I think increased multi-state activity is a possibility. I mean, I think they're signaling that that will be the case. A lot of offices, have dramatically increased the size of their consumer protection groups or divisions. The reason I say possibly is there's just so many priorities. I mean, obviously, Democrat AGs are filing tons of lawsuits at any number of Trump executive actions that are under assault. Focus on emerging technologies. I think that is reinforced by the topic at DAGA, that it's, obviously consumer protection is traditional role of a state AG, but I think that they're signaling that it will be ever broader in application of the consumer protection laws to address emerging technologies. And then I guess lastly, I expect to see some state legislative actions mirroring the Chopra report advice, which was, I think, issued January 15th. And, it's quite thorough and substantive in its advice. John ran through a few of those recommendations. Others are granting pre-suit investigation powers where they don't already exist, eliminating a reliance requirement, adding abusive to take sort of the burden of proof off of states or plaintiffs. And there are some examples there on junk fees. Elimination of junk fees was another piece of advice. So, I am thrilled and honored to be on a panel with such esteemed colleagues. I do see there are a couple more questions. I want to make sure that, honestly, it's more important to get the benefit of that knowledge. But of course, happy to answer, any questions, and please reach out after the presentation.
So I think, we've only got a few minutes left, but there's a really interesting question to maybe end on. And that is, are any of you at all concerned that the CFPB will shut down illegally? In other words, not by an act of Congress? Any concerns?
For me, I'm not sure that I have concerns about it. I don't see that as the likeliest outcome here. I think like I said, we already have the history of the first administration and its term and how they dealt with the CFPB. I don't think that there's an appetite from all Republicans to shut it down. So I don't think that is the most realistic outcome. I think that what you are likely to see, from my personal opinion, is a realignment of priorities. I think you could see a reduction in the number of employees, and particularly in supervision, and maybe less so in enforcement. I think those are the likeliest outcomes for me.
Yeah, and I agree with Ryan, although in preparing for this panel today, we went back and forth a little bit on how Trump 2.0, it feels different than Trump 1.0, right? And after he won the election, the political pundits were saying that he intended not to put as many Washington insiders on his team as he has the last go around. And I think that's exactly what he's done, which has contributed to a little bit maybe more instability and in a different approach than Trump 1.0. So it feels different, but I think ultimately we're going to land exactly how Ryan described it.
So I guess I would say my thought is, it won't surprise me for that to be announced. We've seen a lot of that where we come in, we see an announcement of some big action that's taking place, a lot of noise around it, maybe keep people off balance, but ultimately, do I think that they would do that? I don't. I don't think there are the votes in Congress to do it, as Ryan, you were saying. And it does sort of get back to that question we had. Do we think at some point that they'll start talking about the good that the Bureau has done? Certainty around rules. We at least understand the rules of the road. Now, how they get interpreted may change administration to administration, but yeah, it's going to be interesting. I don't think ultimately they will intend to do that. So it's going to certainly be interesting.
Yeah, and I think that what we're seeing with clients right now is they're getting pressure from their business at times, right? That the business is reading a lot of these articles and they're talking about the CFPB being either defunded or completely shuttered. How do you deal with those from an in-house perspective? I mean, my perspective is those are really difficult questions because they're asking you to look into the future. But again, we have the benefit of history here in pointing to what has happened under the initial Trump administration. So, but if you guys have any additional thoughts on how does an in-house team deal with the pressure of the business at this point, saying be aggressive, you know, they're going to shutter this agency and let's move forward aggressively.
I'd say just exercise caution, understand we still have to comply with the law. Even if the Bureau is gone, we have the AGs, we have the FTC for some of this, we have the Department of Justice, you know, and having dealt with all of these agencies now for a number of decades, they will step into the breach. Remember too, you've got your state regulators and they're going to step in as well. And they're going to be looking. They don't want to be blamed for the next financial crisis, which is part of what happened during the Cordray administration. And part of the impetus for this was during the last financial crisis where I had the dubious pleasure of being in-house at a subprime mortgage lender. That didn't end well. You know, it's challenging. They don't want to be in that situation. So certainly recommend caution, be careful. Remember that these agencies look backwards. Yeah, this agency, it's Republican, may not have as much trouble, but the next one, we just want to exercise some caution.
I think that's a great point to end on, and I'll bring us home by reminding you of a few items, housekeeping items. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be mailed to you tomorrow, along with a recording of the webcast for watching and sharing. Please be sure to complete our short survey. We use your feedback to plan future programs. I know we will all continue to be on the edge of our seat in the coming days, and we so appreciate you joining us this afternoon. Thank you.